I'm going to recognize the very distinguished gentlelady from Massachusetts, Ms. Pressley, whose beautiful district I got to visit during the recess. Ms. Pressley, you're recognized for your 5 minutes.
Thank you so much, Chairman Raskin. Fossil fuel companies have abused the legal system to escape accountability for their role in exacerbating the climate crisis and endangering frontline communities, which I represent in the Massachusetts 7th. And today's hearing really does underscore why we have to put an end to their attacks on environmental justice organizers and climate activists once and for all. Strategic lawsuits against public participation, known as SLAPP suits, they've been used across the country by big oil. For example, when several California cities sued Exxon for damages related to climate change, Exxon brought a countersuit, not in federal court, but in a Texas state court, seeking to depose California residents for actions taken only in California. Now, this was complex and dubious lawyering to try and create a racketeering or RICO case against the residents and municipalities. Professor Ramastri, can you tell us about how this case fits into the way big oil companies and SLAPP abuse works?
Thank you, Representative Pressley. I think the larger issue, and what I tried to illustrate without getting into each individual case, is to say that there's a larger strategy here, which is not only within the United States, but global. And I appreciate what we're hearing from all members here about the issue of balance. What we're seeing is, and I would say that one of the issues is that there are certain parts of the legal profession who have really taken up this. So it's not just about the companies, but it's also about the law firms sort of pursuing these zealous tactics where there's a clear imbalance of power. We've seen the results are in these suits that the companies typically don't prevail, but they prevail in terms of the duration of the suits, the cost of the suits, and the inequality of resources that governments and or civil society groups have, right? So this is the larger issue that I want to highlight. And so again, we need to rebalance. These suits really represent that inequality of resource and power, and rebalancing through things like anti-SLAPP legislation. I was part of the Uniform Law Commission, which is a 50-state bipartisan organization that is focused on cooperation and balance. So I come to you here today saying we do need balanced solutions, but we have a situation now of tremendous asymmetry. Thank you.
And do you mind, Professor, just expounding upon exactly what was the ultimate outcome of that litigation and how long did it take?
I do not know the ultimate outcome of the Exxon case that you're talking about. I mean, as I understand it now, it is it has been dismissed, and that on appeal, that dismissal has been upheld. But the specific grounds I can't speak to.
And I think that took about 4 years to litigate. Thank you.
And I would just say 4 is actually relatively short compared to some of the other cases that have been mentioned in today's hearing.
And although that lawsuit did not work, it did not stop the lawyers at Exxon, at all from continuing to abuse the legal system. In fact, in my home state of Massachusetts, our Attorney General, Maura Healey, filed an action against the company seeking damages for sea level rise related to climate change. And in response, Exxon filed a special anti-SLAPP lawsuit against the state. So Exxon was hoping to use the very law that is designed to stop them from avoiding accountability as a mechanism to avoid accountability. Professor, are you aware of any instances where anti-SLAPP would be appropriately used against state enforcement or regulators?
So I don't. And again, if you look at different laws that are dealing with sort of anti-SLAPP, they have different types of application of scope. But again, I think the question of balance is that quite quickly, if you see it as a counter tactic, a court has the ability to make that decision fairly quickly. So again, these laws can be used by companies as well as by a civil society, but the question is, at a very early stage, a court has the ability to say this doesn't have merit and to dismiss it if a company, again, is using this tactically as opposed to really to deal with an underlying legal issue.
But it is a consistent tactic sort of in this playbook, of powerful entities like the fossil fuel industry. It's a consistent tactic.
Consistent, I guess I would say that the larger issue is that it's part of a larger consistent approach to using the legal system and to create a prolonged, resource-intensive approach to an issue.
Very good. And in fact, in the Massachusetts Supreme Court, after more than 3 years of litigation, denied Exxon's motion and is allowing the matter to proceed. So 3 years. So these delay tactics and judicial harassment by Exxon, by Chevron and others really only serves their greedy interests and harm our planet. I represent one of the district's frontline communities disproportionately impacted, some of the highest rates in the country. So like justice delayed is justice denied. We cannot allow big oil to continue using the legal system to escape accountability. It's really all it comes down to. So thank you, and I yield.
Thank you very much, Ms. Pressley. I now recognize